order and then turn it over to Supervisor Budke.
And I'll call the Health and Human Services Committee meeting to order as well.
So we'll start with public comment. Public comment, do I have a list, Kim? First, we have Aaron Crawford. Go ahead, Aaron, if you're on the phone.
Yep, I'm on the phone. Can you hear me?
Yes.
Great. Okay, I just have a few questions for the supervisors as it is discussed and consider the decriminalization of marijuana possession today. Just wondering, why do we want this reduction in fines in our community, and what precedents does this set? How will this affect the current drug problems that the county is facing? Just looking at the Health and Human Services agenda from last month, there are slides covering the crisis on opioid overdoses and current death rates. Marijuana is the gateway into all of these other horrible drugs. What is the difference between someone being caught with, say, the new 25-gram limit and a person carrying 24 grams of marijuana? Both are illegal, and why should 1 gram make a difference and be charged less? It's clear from much evidence that marijuana harms communities and our children. It puts stress on public safety and our healthcare system. This decriminalization simply encourages more marijuana usage. And keep in mind, this isn't the same marijuana use or type of marijuana as seen in the 1970s. It's far more harmful. So I just believe it's a terrible idea, and it's just the acceptance of more lawlessness happening in our country. So thank you for your time.
Thank you, Aaron. Next, we have Joanne Leonard. Yeah, it should be.
Good afternoon. First of all, I just want to say, okay, thank you. Is it on now? Yep. Okay. Thank you for the opportunity to speak to this issue. My name is Joanne Leonard. I live at 923 Maple Hill Road in Wausau. First of all, I'd just like to comment that in reading the agenda, it's pretty difficult to figure out what you're planning to do today. So my comments may be drifting off into another area that you're not going to address, but I think Aaron just commented on what this whole issue is all about, and that's a reduction of the $50 limit for 25 grams of marijuana use in Marathon County. So I'm here to oppose this for moving forward and for initiating a reduction in penalty for the marijuana in the marijuana ordinance. It's not legalized at the state level or the federal level, and I'm well aware several states have implemented their own legalization of marijuana, but just because one state does it doesn't mean we should follow in line with everybody else. Talk to those states about the many issues surrounding their legalization. How do kids, and I have kids in quotes, get hooked on drugs? Let's start out young, and the drug of choice is marijuana. It is cheap, easily accessible, and fun to use until the thrill runs out, and then a dealer offers them another option or a stronger marijuana than what they're actually using. We never hear the numbers of felonies and crimes that are committed while people are on drugs. People do things on drugs they would never do if they had their mental capacity. Alex Berenson wrote a book, Tell Your Children the Truth About Marijuana, Mental Illness, and Violence. He gave a speech at Hillsdale College in 2019 about the very issue this group of elected officials is talking about today. This author said there is a big gap between people promoting legalization as a low-risk way to raise tax revenue and what a sadistic way to generate tax base. How about spending less tax dollars? There is a huge lobby campaign to push public attitudes about marijuana as safe and can help the person medically. After an exhaustive review, the National Academy of Medicine found in 2017 that cannabis use is likely to increase the risk of developing schizophrenia and other psychosis. The higher the use, the greater the risk. Then combine the link between mental illness, drug use, and crime. Why do we never hear anything about drug tests when people are committed of crimes of all types and it lowers their resistance to be cognizant of what they are actually doing. With crime rates spiraling out of control around the country and in Marathon County, why would this body of smart, intelligent people concerned for the safety of all residents bring this ordinance forward one more time for review, other than to say they made a mistake and should rescind the ordinance? That would be my suggestion. Thank you for your time.
Thank you, Joanne. Keith Yeager.
Hello. Thank you for allowing me to speak today. I knew nothing about any of this ordinance, proposed ordinance, until I heard something on a local media station this morning in regards to this 2 o'clock meeting. So I'm a little, I had to do a lot of quick research. As I understand it, possession of less than 25 grams, which is like 0.882 ounces, about 7/8 of an ounce, would involve a forfeiture of just $50, so it'd be like a misdemeanor. I understand how the police and the court system are packed with, they have full dockets right now, especially with the way that, COVID has been treated and people have been scared by that. But my emphasis today is going to be on teenagers and the message that this proposed ordinance would send to them. I believe that this statute would embolden and encourage more young people to try marijuana that now maybe see it more as an illegal thing to steer clear of. It makes it more accessible for adults and teens to have these amounts. Older siblings could more easily be emboldened to have it and get it to their younger siblings who are in high school, middle-age type schools, even younger. Research has pretty clearly shown that the teen brain is still actively developing until the mid-20s. And marijuana also has been researched to show that it has effects on these teen brains. Things like difficulty in thinking and problem solving, problems with memory and learning, difficulty in maintaining attention, declines in school performance, increased risk of mental health issues, impaired driving as they become 16 and have the ability to drive. And there's the potential for addiction. So all of these are negative issues in both adults and kids alike. And for the last many decades, a lot of employers require drug screening and drug tests. And among those are for marijuana use. So if we're encouraging, in some ways with this statute, more marijuana use, I think that conflicts with the values of the business community. I also have a personal stake in this. My son, we have sent to a school in Georgia. He's 17 years old to finish his high school. He had gotten addicted to the modern marijuana, which is, I understand, could be up to 10 times more powerful than in the 70s when I was his age. He's suffered as an addict in some ways. He's got memory loss as we try to talk to him about different things. He just doesn't remember some of the situations that he was involved with. He developed behavioral issues, coping skills. Now, granted, we have culpability in that. Other people he was around have culpability in that, but the marijuana certainly was a major contributor to it. Fortunately, he's in an environment where he's in a wooded area. They have very limited computer use. They use textbooks. He's thriving. He's doing really well. We just had a Zoom call with him this morning, him and his therapist, and I don't know, I'm proud of how he's doing. But it doesn't negate the fact that we had to send him to this place. And I just want you to, all the people on the committee, to look at these facts, the medical facts that are out there, and testimony that you're going to hear, and this really highly consider that as this statute is considered. Thank you.
Thank you, Keith. All right, then moving forward, policy issues, discussion, potential committee determination, none. And then we'll move on to 4A, updating the marijuana possession ordinance. I will start. This agenda item was a request by Supervisor Jeff Johnson. Before I invite Supervisor Johnson to make his presentation, I'd like to provide some brief background on this item. Before we begin our discussions, I think it's important to note that the possession of marijuana continues to remain a criminal offense at the state and federal levels. This is the law and is not within our purview to change. What we're going to do is basically give Supervisor Johnson his chance to speak. Then we're going to listen to Corp Counsel with some input, the DA with her input, and then from the Sheriff's Office, Chad Billop. So with that, I will turn it over to Supervisor Johnson.
Thank you, Mr. Chair. And you're absolutely right that there is a limited scope to this, and there's an existing ordinance that I'm proposing updating. Now, the reason I'm bringing this forward is I had a number of constituent contacts who requested that I bring this forward. This just didn't come up out of thin air that let's update this. A lot of folks asked me about this specifically, and they wanted it to go farther, and I informed them that the county only has the authority that the state legislature grants. You know, we don't have the ability to go beyond what the state legislature allows us to do. And in this case, it's relatively prescriptive on a marijuana ordinance. Now, to them, and I agree, it would be a much better course of action if the state would take action to legalize, regulate, and tax marijuana and get it out of the criminal underground of drug dealers. I think that would be a positive thing overall for the state, as many other states have done. However, that's not an option. So what we have is a situation where folks who live in Wisconsin can go to surrounding states, legally purchase marijuana, and I'm talking about adults here. Nobody wants to see this in the hands of kids. Nobody does. But we're talking about a wide cross-section of folks in Marathon County. I don't care what kind of profession you're talking about, what kind of socioeconomic class you're talking about. There are a lot of people who smoke marijuana or ingest THC in some form or another. And the impetus behind this is to give those folks who are using it responsibly some sense of security that they're not going to be entered into the criminal justice system. Just like somebody sitting on their back deck having a beer after work is not going to be put into the criminal justice system. Now, I understand the distinction. On the federal and state level, marijuana is still illegal. But I think we need to recognize the reality that it is widely used and widely used responsibly by a lot of adults. And our current statute, our current ordinance, just seemed a bit punitive and out of whack. Now, we're not allowed to make it legal. We're not allowed to do anything other than what the state legislature has allowed us to do, which is for 25 grams or less, we can set a fine, treat it as an ordinance violation. Some counties have gone to the limit, like Milwaukee County, it's a $1 fine. Other counties have a $100 fine. Some have 50. It really is all over the board. Now, there is pending legislation right now, and it's bipartisan legislation, to change that statute to allow for a $100 fine, period, just to kind of standardize it across the state, and that bill has bipartisan support. It has not gone to hearings yet, and whether it does or not, it also lowers the possession limit from 25 grams to 14 grams. That would be fine. But until that's enacted, we have to work with the parameters that the legislature has given us. Now, we've had prohibitions in this country on other substances before, and it was wildly unsuccessful. We all read about the Roaring '20s and the prohibition and the gangs that sprung up with the illegal trade of alcohol. That was repealed. A lot of Wisconsinites responsibly enjoy a drink here and there. A lot of Wisconsinites responsibly enjoy THC here and there. The prohibition has been unsuccessful. It's been in place for about 90 years on the federal level. And it's, like I said, wildly unsuccessful. Responsible people use it responsibly. Irresponsible people may not. Are we such a nanny state that we can tell people you can't use something because you may be one of the irresponsible people? Irresponsible people will be dealt with by the criminal justice system. I think responsible people should be able to live with the assurance that if they use marijuana responsibly, they will not be entered into the criminal justice system. And this does have benefits for us. We would have reduced caseloads. I do want to address one liberal myth which is out there, that the prisons are full of people for possession of marijuana. They're not. 25-year career in corrections has taught me that I never saw anyone in prison solely for possession of marijuana. I did see hundreds and hundreds and hundreds of cases where people were serving longer sentences because of possession of marijuana, because a second possession is a felony and then it's a repeater and it raises the exposure of prison time. So that is the impact that it has on the criminal justice system in a big picture sense, is that it lengthens sentences by having it criminalized and having it treated through the criminal justice system. Now, hopefully, we're going to get this bipartisan bill passed in Madison, which would address a lot of these concerns. But until it does, we do have the power at the county level to make these changes. And by reducing the fine from $250, treating it much like you would a parking ticket, reducing it to $50, I think it is commensurate, while recognizing it is still illegal, but it's commensurate with the level of risk that responsible adults are putting the county at, which is absolutely none. But it still recognizes that it's illegal and you do incur a penalty for it. You know, because there are a lot of folks where $250 is a lot of money. And if they're not up to anything else, they shouldn't be in the criminal justice system. Okay, so some of the concerns that were raised, I did meet with Wausau PD, the Sheriff's Department, the District Attorney, to hear what their concerns were. And some of the concerns, quite honestly, it was a little bit vague. Nobody, I think, really wanted to put things concretely out there. Now, one of the things, concerns of law enforcement that I heard was that there could be increased drug use in other areas, specifically looking at opioids and looking at opioid addiction and overdoses by states. And Chief Deputy Billup brought up a chart from the Rocky Mountain Law Enforcement, which showed that marijuana use went up when it was legalized, and as did opioid deaths. Now, I'm here to tell you, I could put up a chart of the Dow Jones Industrial Average going up and opioid use going up right along with it. They don't have anything to do with each other, just like the use of marijuana and legalization of marijuana has nothing to do with opioid use and abuse and overdoses. I did take the liberty of printing out from the CDC the latest statistics on overdose drug mortality by state. The states with the highest mortality of drug overdose are not ones who have legal marijuana. State of Wisconsin ranks towards the middle lower part of the pack. And I do have copies of this for all the committee members and anyone else who is interested. But there is no direct correlation between opioids and marijuana use. There really is not. And marijuana is not a gateway drug in the sense that just using it leads you to other drugs. The only way and I say this as a retired probation parole agent who supervised a high-risk gang and drug caseload for 10 years. The only reason marijuana can vaguely be considered a gateway drug is because right now in the state of Wisconsin, if you want to buy marijuana, you've got to go see a criminal who wants to sell you other things. And it puts you in contact with that criminal element. It really does. And they want to sell you something that's more profitable. So in that sense, it's a gateway drug. It is physically non-addictive. It is safer than alcohol, significantly safer than alcohol. No one has ever died from a THC overdose in the history of this country. Alcohol overdoses happen all the time. They do. It's unfortunate. Long-term, alcohol is physically addictive. THC is not physically addictive. The jury is still out on whether it is addictive as far as your mental health. I mean, there are issues. Kids should not be using it. I'm not saying they should. But used responsibly by adults, it's significantly safer than alcohol. Significantly safer. Now, one of the things I learned when speaking with Chief Deputy Billup is that even drug dogs are no longer being trained to sniff marijuana. And I surmise the reason for that is it's legal in so many states that it wouldn't hold up as probable cause for initiating a search if the dog alerted on a vehicle. Because if the dog isn't differentiating between a legal substance and an illegal substance, it just kind of shows to me where the trend is going if drug dogs aren't being trained to detect marijuana anymore. And eventually the state of Wisconsin, I believe, will legalize it, regulate it, and tax it, which would be a good thing. Now, yesterday there was a press conference here in Marathon County, right in the courthouse here, about staff shortages in law enforcement, where law enforcement agencies aren't getting the same number of recruits they used to, the same number of applicants, same number of qualified applicants. And they're overworked and they are stretched thin, as is the district attorney's office, as we've heard on multiple occasions how stretched thin they are. All this does is give them a tool to issue a ticket for $50 and bypass that person going into the criminal justice system. Be very clear on this. It does not compel them to use it. They do not have to use this ordinance. Which is kind of interesting to me, because when I spoke with the chief of Wausau PD and the deputy chief and the chief deputy and the sheriff, every one of them said, I don't want my officers or deputies criminally charging people for simple possession. I heard that over and over. Well, then don't. It is that simple. It takes leadership from those agencies. But again, this change does not compel them to do that. And I'm only advocating for this. I believe that if there are no other criminal circumstances involved, this should be used. If there's other criminal activity going on, they always have the option to use the state criminal statutes to charge it. This ordinance does not handcuff them in any way, does not restrict them. I would like to see them adopt its use on a more widespread basis. But be clear, it does not require them to do it. Nobody's being told they have to do anything here. It just gives a tool to keep citizens out of the criminal justice system. And I hope that's a direction that we're going to go to. Now, I'd be happy to answer any questions. And again, this is not something I sought out. It was brought to me. And I have spent time in states where it has been legalized. And I did meet with local, state, and county officials to speak with them, as well as cops on the street. And I recall a conversation with a patrolman in Denver, Colorado. And I asked him specifically, how has it been for you and your officers on the street? You know, what have you seen? Have you seen increases in crime? Have you seen decreases in crime? What's going on? He said, well, the only area of increase in crime we've seen is people trying to break into dispensaries because it's an all-cash business due to federal banking regulations. He said, otherwise we've seen decreases in daily activity and drug busts because we don't have people going to a drug dealer to buy pot. City councilmen, county officials, state officials told me about the same thing. So I actually went out there to sit down and talk with them on this because I don't want to be speaking anecdotally without having some personal contact with them or personal interaction. So that's why I'm proposing this. Now, Corporation Counsel did make me aware that the update I'm proposing has a problem, and I would leave it to him to go through the legal change that would have to be made to be in compliance with statute, because we do want to be in compliance, of course. So at that point, I would open it up to anyone who has a question from the committees or to Corp Counsel to clarify what needs to be done to bring us into compliance.
I think if it's okay with Health and Human Services, we'd hear the other three people, and then we take questions for whoever that spoke during the, is
That would be fine.
Okay. So that's the way we'll move forward. Then we'll go to Mike. Why don't you go ahead and start?
Thank you, Mr. Chair, and thank you, Supervisor Johnson. I did have a chance to speak with Supervisor Johnson prior to today's meeting. The part of the proposed revision that I pointed out was the current proposal would remove Section 4B from our existing ordinance. 4B currently reads that if a complaint is issued, and that's referring, I think, to a criminal complaint for a state law violation of possession of marijuana. If a complaint is issued regarding an allegation of possession of any amount of marijuana following conviction in the state for possession of marijuana, the subject of that complaint may not be prosecuted under this ordinance unless the charges for violating the state statute are dismissed or the district attorney declines to prosecute the case and the city, village, or town with jurisdiction over the action has no ordinance enacted. So that provision to me reads as a protection against double jeopardy, where someone could be charged in state court for violating state law and then also receive a county ordinance violation for the same act. The reason it's not protected by constitutional double jeopardy protections is that our ordinance violations are civil, so the double jeopardy clause doesn't apply. State law actually does outline what the county can do regarding regulation of possession of marijuana, and that statute is 5954 sub 25. Sub A of that statute does mirror the language that's in our existing ordinance, and my read of that is that if the county is to enact an ordinance and prohibit the possession of marijuana, that exception that's currently outlined in the ordinance and in the state statute is also required by the county. So I think the revision removing Section 4B would likely be contrary to state statute. So I wanted to point that piece out.
Thank you, Mike. Then I'll go ahead and turn it over to Teresa.
Thank you very much. I'm Teresa Whetstone. I'm the district attorney in Marathon County, for those of you who I don't know. I appreciate the opportunity to speak today, and I want to, there's a number of things I want to go through, but I do want to emphasize what Attorney Pierner just stated, which is that provision sub B is actually a protection for individuals who are facing a penalty for possession of marijuana. It prohibits the district attorney's office from seeking a citation if the individual is also convicted in criminal court for that same possession of marijuana. So to eliminate that not only would be, I believe, contrary to state statute which authorizes the county ordinance, it would be removing a protection for individuals that is a very proper and necessary protection that can only be afforded through the language of the ordinance, because as Attorney Pierner said, it is a civil ordinance. So having said that, I'm definitely opposed to removal of sub B. I want to, I guess, start by clarifying a few things. First, maybe I should just remove my mask. Huh? Is that all right? Okay. First, there was some, I got a little confused, I guess, in Supervisor Johnson's statements in that there is an ordinance in place. This is not a discussion about passing an ordinance to give an option for a civil citation for possession of marijuana in Marathon County. That already exists. So in reviewing this ordinance change, this was actually a very positive experience for the district attorney's office, and I think in working with the Marathon County Sheriff's Office as well. It gave us an opportunity to look at what's actually happening in Marathon County. And I know you stated that you got some of the latest statistics, and I want to come here and share with you, Supervisor Johnson, and the public, the statistics as it relates to Marathon County, because that hasn't been discussed with you. And I think it's important to understand what we as a county, what the district attorney's office, the Marathon County Sheriff's Office have done in collaboration to seek justice for these cases and ensure public safety, which are some of the concerns that I heard raised here today by the public comments. So with regard to the ordinance enforcement, I've read and I've now heard again that this ordinance will somehow correlate to easing the burden in the criminal justice system or easing the issues of understaffing in the district attorney's office. Please understand that the prosecution of ordinance violations is done by the district attorney's office. It is not done by Corporation Counsel, and it must be done by the district attorney's office. So it is still our staff that would prosecute the ordinances. We have been looking at the prosecution of THC in the district attorney's office and talking with law enforcement for years. I don't know if Deputy Chief Philip could tell me how many, or Deputy Sheriff Philip could tell me how many years we've been doing that. But it's been years. And one of the things that concerned us is instances where individuals are only in possession of marijuana and are stopped for maybe some other reasons, such as speeding or something of the like, and they're in possession of marijuana. At that point in time, if a citation is issued, unlike the city of Wausau or other municipalities, if a citation is issued through the Marathon County Sheriff's Office, it goes on Wisconsin Circuit Court access. It is public. It is on that website, whether they contest it or they end up pleading to it. That is different than other municipalities. So we looked at what are we trying to, how is it connected with public safety and justice? And so we have a diversion program in Marathon County that prior to, instead of issuing a citation that goes on to the Wisconsin Circuit Court access, first-time offenders can be referred to the district attorney's office, and the sheriff's office has been great in working with us in that regard. And there would be no entry on their criminal history. There would be no arrest. It would be a referral. And then if they are appropriate for diversion and they accept diversion, there would be no entry on CCAP. So for these first-time offenders, that actually can be more beneficial in that regard as to a public record of that contact than a citation. If they choose to participate in the program, then there may never be any entry on CCAP, or wouldn't be for at least that offense. In addition, there were some concerns raised about marijuana being a gateway drug, about marijuana being used as treatment for maybe underlying mental health issues, an escape drug, that type of thing, going down a bad path. The diversion program for first-time offenders, assesses that individual to see if there are those underlying issues and individualizes the program for that offender rather than a across-the-board $50 fine, individualizes that program for that individual offender, doesn't overtreat, doesn't undertreat, but addresses the problem, or can address education, talking about the health impacts for young users, the possibilities of being addicted to the feeling of use of marijuana, all types of things like that. The diversion program is a wonderful opportunity to intervene with those offenders to hopefully reduce recidivism down the road. So we're trying to address the problem through that. So I wanted to look at what the statistics are as far as Marathon County and how, as Mr. Johnson stated, there is tremendous discretion with regard to the Marathon County Sheriff's Office. So this ordinance is only used by deputies at the Marathon County Sheriff's Office. It's not used by Wausau police officers, Everest Metro. We're talking about the Marathon County Sheriff's Office. So in 2021, for example, there were, well, let's take the last 2 years because the pandemic has been strange and we'd have to take that into consideration. The DA's office issued 7 felony, that means second possession type marijuana charges, 7 in 2 years that were from the Marathon County Sheriff's Office. And all of them were accompanying other criminal charges. So only one case, and in 6 of the 7 in those 2 years, the felony, with or without that THC charge, there was another felony offense unrelated to THC possession. So there would have been a felony case regardless. And in the other, it would have been another charge, but a misdemeanor. So just to have some understanding, and in that one, by the way, that was issued, that wasn't another felony charge. It was an individual alleged to have been going the wrong way on a one-way street, and there was operating after revocation related to a drunk driving conviction. So there were other circumstances. So the use of the felony, which is the second and subsequent THC, has been very minimal in Marathon County, and it's connected with public safety as it relates to getting to some of the rehabilitative issues of these offenders. Then with regard to misdemeanors, in 2021, so for the full year in Marathon County, there were 37 referrals for the year for misdemeanor possession of THC. And none of those referrals were for first-time criminal offenders. None of them. So there is an ordinance in place. The Marathon County Sheriff's Office and their deputies have the ability to use the ordinance for first-time offenders, and what we're seeing in the DA's office is not first-time offenders. So we charged out 35 of those. Of those, 19 were felony cases. So if an individual burglarizes a residence, as an example, and that's a felony, and they are arrested and they're in possession of THC, that would be an accompanying charge with a felony. It's in connection with some other criminal felony conduct. Certainly something as someone who is responsible for accountability and public safety would want to be aware of and hold that person accountable. Of those, so 19 of the 35, 10 had accompanying misdemeanor charges besides the possession of THC. 5 ended up having accompanying forfeitures, and 1 was a juvenile case. So there were, what I wanted to know then is of the 10, because this is an opportunity to review what we're doing in our office and how we're handling these cases. So of the 10 misdemeanor cases that were charged, 7 of them, the sole count was possession of THC. So even though there was only 7 for a year, I thought it was important to see what those 7 were. And in 6 of the 7, the individual had other either pending charges in different cases or criminal history that was significant and concerning, and they were on supervision or other circumstances. So I actually went into those cases and looked at those individuals and their circumstances to have a review of what our prosecutors were doing. And I was happy to find that there was an articulable reason as to why, connected with public safety and recidivism and rehabilitation, that individual was charged. So I think this is a wonderful opportunity to highlight some of the things that we are doing in Marathon County. Let's see. I do want to say that there are a lot of discussion or talking points with regard to this issue, and nothing is simple about this. There's legal analysis that needs to be done because the authority to issue an ordinance comes through state statute. There is an analysis that I think is necessary to look at what we're trying to accomplish in Marathon County with regard to people possessing THC. And it's not going to be the same for every individual. And it needs to be connected with our overall goals of public safety and reduction in recidivism. And I think that, I hope that this is an opportunity for the public to have a better understanding that there has been years of discussion and thoughtful analysis and collaboration between law enforcement and the DA's office and our diversion program on how to best address this issue. And I'd also be happy at any future meeting to share our diversion program statistics or whatever. I think I have shared them in the past, but so I appreciate that this was brought forward because I think it is an important issue for public education. It's very important that our leaders are putting forth proper information as far as it's supported by law and statistics, and that our Marathon County residents really understand truly what we're doing in Marathon County and what we're facing and how we're handling it. And because it's not something that, we typically have an opportunity to address. So I really appreciate the time today to be able to address that, and I'd be happy to answer any questions afterwards.
Thank you, Teresa. We have next Chief Deputy Billup.
Oh, okay.
I'll just sit right here. Thank you. For those of you who are on our remote, my name is Chad Billup. I'm the Chief Deputy of the Marathon County Sheriff's Office. And my intent here today is just to share a little perspective about what it is that our deputies do every time that they encounter one of these types of calls or situations. I think it's important to note that in all of their work, their daily work, discretion is a large part of what they do. In addition to that discretion, they also have guiding principles that direct how they do their work, whether it be a statute or an ordinance. And what they always rely back on is, what is the law? And what does the law tell us, and how are we going to enforce that law, enforce it as equitably as we possibly can when we're doing that work? I understand that there's some confusion around the premise behind changing the ordinance, what impact would mean. And I just recently learned today about the provision about double jeopardy. I had not envisioned that as being an obstacle to doing this, but at face value, when I looked at the suggested revision, I believe that there was a perception that this would somehow decriminalize marijuana in Marathon County, and that quite simply just is not the case. It would not do that at all. The ordinance as written today, and even if it was revised, would not change how we do our work at the Sheriff's Office. Regardless of grams, regardless of whether or not 4B remains in, our deputies will still do the same work that they do every day, and they will enforce the law as they have always enforced the law. To the DA's point, we've done considerable work within the last few years around diversion and something that we used to call the proxy. And the proxy is a tool, a decision-making tool that officers use that help them decide when it's appropriate to make an arrest, a physical arrest, or to actually take someone into custody. And what happens is those decisions are made every day, and they don't need to have a rubric in front of them or some sort of a matrix in order to help them make those decisions. But when they encounter a situation, they know what to do because they fall back on the law. And in addition to the cases that the DA presented to you today, there are a number of cases that I know get funneled to her office, but the reality is people just pay their tickets and they never get assigned to a prosecutor. And those are those ordinance violations that we write. And on average, we're writing about 50 possession of marijuana tickets a year. You have to then add on to that the cases that DA Whetstone just referenced, which are the ones that our deputies determine are criminal in nature. So what that tells me, and in my conversations with the DA on this issue and others, is our deputies are doing a pretty darn good job of going out and interacting with the public and making decisions based upon the facts that they have in front of them and making appropriate recommendations to the DA or issuing citations. I would liken it to a speeding violation. There are plenty of people that are out there driving every day. They're going 30 miles per hour over the speed limit, but we will stop them and we can make a decision on the spot. Am I going to write you for 30 miles per hour over the speed limit, or am I going to write you a ticket for 10 miles over the speed limit? That will happen independent of any change to this ordinance. The same balancing test will be done by our deputies, and they will continue to make decisions tomorrow, just like they are today, regardless of the change. So that now brings up the bigger challenge and the question, which is that of the $50 or the forfeiture or whatever that may be. And what we're learning, and this, again, because of this topic being brought up, is there's a lot of confusion around that. There's a lot more analysis that needs to be done because our ordinances all have a dollar value. And as an example, when our deputies go out on a call, and I'll use disorderly conduct, harassment, criminal damage to property, disorderly conduct with a motor vehicle, they go and they investigate that incident, they make a decision to issue a citation, they plug it into their computer nowadays, and it spits out a ticket. And on that ticket is a penalty amount, the dollar value that we assess, or that is assessed to the citation. Where does that dollar amount come from? How is it derived? I don't know. I just know it's there. So as we start talking about what these amounts are, I think we need to do a deeper dive not only into the marijuana citation, but I think all of our ordinances, I think we would all benefit from a better understanding of how do those come about for all of the violations that we have in our toolbox. I think my biggest message here today, and one to put the public's mind at ease, is that the Marathon County Sheriff's Office has no interest in decriminalizing marijuana. We will continue to enforce state laws, just as we always have, and we will continue to enforce our ordinances as we always have. If there's more questions at the end, I'd be happy to answer those.
With that, we might as well just open it up to all the supervisors and, of course, Supervisor Johnson. Any questions or further comments from anyone? Go ahead, Supervisor Johnson.
Thank you, Mr. Chair. When I listen, and the DA and the chief deputy, and I always think it's funny because I work with Wausau PD a lot as an agent, and there they have a deputy chief, and in the sheriff's department they have a chief deputy. It was always kind of confusing. But he raised the point, they both raised the point about the diversion program. And when I think about the diversion program, a diversion program to me, having worked with many of them during my career, is a way to take a budding criminal and show them another path. Help them find another way, divert them out of a harmful pattern that they're getting into. When I look at responsible adults using THC, again, no different than somebody having a beer or a glass of wine after work. They don't need a diversion program. Everybody in possession of marijuana does not need a diversion program. And if they pay their fine as stated, it does not end up on CCAP, regardless of who's prosecuting, whether it's the district attorney or the corporation counsel. Parking tickets all go through there. It was just raised to me. And it's also not going to be listed as a criminal case if it is an ordinance violation. As someone who uses CCAP on a very regular basis, it's very easy to spot whether there is a criminal offense or an ordinance offense. And the difference is glaring when you look at somebody's CCAP record. So even if it is listed on there, it's not listed as a criminal offense and would not carry that same weight going forward. But my point is that in this case, diversion for so many people, not saying it wasn't appropriate for some, but for so many people would miss the mark. And I would hate to see the county go in a direction where all possession of marijuana would require, or in order to be an ordinance violation, would require some kind of process through a diversion program. I just think it would be counterproductive in a lot of cases and unnecessary in a lot of cases. So I don't want to see that put in as a standard, and I hope it doesn't come out that way. Like I said, for some it is very appropriate. But with regard to, you know, your attorney in town who likes to have a little marijuana after work on occasion, they don't need a diversion program. They're productive parts of society, and there's a lot of professionals out there in that same boat. There's a lot of people in every walk of life in that same boat who are taking care of themselves, living good lives, taking care of their family, being law-abiding. They just use THC occasionally, and they don't need a diversion program. Some people do. I'm just afraid that if we lump everybody together and say diversion's the way to go, I don't think that one-size-fits-all approach would really be beneficial in the long run, and I think it'd be more costly than it would have to be. Thank you, Mr. Chair.
All right, we have Teresa, then Supervisor Van Cray, and then Supervisor Opal.
I just want to clarify that it does go on CCAP. It's very important that people understand and get accurate information on this. It does go on CCAP. Kelly Shrimp is here from the Clerk of Court's office. She can verify that if it's paid or not, if it's contested, it goes on CCAP. And it can affect, actually our diversion coordinator would be a good person to actually speak to directly about diversion and what diversion stands for. And the fact that people are impacted by something being on CCAP like this, even if it is an ordinance, because it's an easy find for individuals. They can just go on, as was just stated, you can just go on CCAP and there it is. It's an easy find. And to believe that everybody understands or appreciates the difference between an ordinance and a criminal violation, that's not necessarily true. So it's the public nature of it. Also, I agree. One size does not fit all. I'm not asking for every person to go through the diversion program. I'll make that very clear. It is not a one-size-fits-all criminal justice system, nor should it ever be. But it's interesting because we're talking about a dollar amount and a fine that would be one-size-fits-all. That's what's being proposed, is a one-size-fits-all fine amount, right? When right now we have between $500 and $500 where a law enforcement officer can use their discretion based on the information that they have as a tool in their toolbox to use their discretion wisely under the supervision of someone who gets it in charge. So I just want to, I guess, make those clarifications.
Supervisor Van Cray.
Thank you, Mr. Chair. I think Teresa just pretty much answered my question, but just to clarify, the officer at the time of the stop gets to determine the amount of the forfeiture between $500 and $500, correct?
No, the way it works is they get to make the decision about whether or not it will be civil or whether it'll be a criminal offense. And we have a bond amount that we use that will at least get them started into the court process. And then that amount can be varied from there once they get into the process, and the prosecutor's office has the ability to work within that range.
Okay, so just a follow-up clarification again. Currently where it sits, it could be $5, it could be $500. Proposed change is to just make it 50 always.
I'm going to confuse you even more, and I don't mean to do that.
Okay.
But this is exactly the conversation that we've been having with the county administrator's office, corporation counsel, the district attorney, and the clerk of courts. Inside of our ordinance, it says anywhere from $5 to $500. Is that a deposit of $5? If it's a deposit of $5, that equates to another number once you add in all the court costs. Is it a fine of $5? Is it a penalty? I mean, there's a lot of definitions we need to clear up, because the way our ordinances are currently structured at the sheriff's office is every single violation we have is standardized. Disorderly conduct, possession of marijuana, possession of paraphernalia, criminal damage to property. They all have a deposit of $90, but that $90 actually equals $250.90 because of all of the additional fees that are assessed. And this is where I think that we need to have a process or a work group in order to talk about not just this ordinance, but every ordinance we have and how we want that to look in the future. I hope that answers your question.
That did. Thank you.
We have Supervisor Opel, then Supervisor Jacobson, and then Supervisor Gibbs.
Thank you, Mr. Chair and Mr. Other Chair. Well, I guess I want to ask what the procedure is going to be. Would each committee vote separately, or would it be a group vote on whether to accept or reject or whatever?
I guess I'll say what I feel, and then Tim can say what he feels on the Health and Human Services. We can either vote on this today, we can defer it, we can do nothing, we can say we don't do anything with it. We can do it, and I don't know if we want to do it as both committees or separate committees. I envision separate committees, but we have a joint committee meeting, so I guess how would you like to see that
I would
go?
defer to, okay, staying separate.
Okay.
I think separate would be the correct way to do the vote.
Okay.
All right, well, then I would ask the Public Safety Committee to reject the proposal as submitted. And I make that motion.
All right, we make the motion, and do I have a second? We still will listen to Kurt.
Lamont, seconds.
Okay, made in second. Okay, we'll have more discussion now for public safety. So go ahead, Brent Jacobson.
Thank you, Mr. Chair. I guess I have some comments and some questions. My thought on this is that as the penalties decrease, I think you're going to see an increase in first-time users. And I also would suspect that you're going to see an increase in first-time users among the younger generation. And I say that because I think it's now more affordable for a younger person to simply violate the ordinance, because now it's $50 instead of $500. And, you know, I took it upon myself to try and do a little bit of research today for what it was worth. And there certainly are many studies out there suggesting different things on both sides of the argument. I found studies to suggest that certainly at a younger stage, while the brain is still developing, that the drug can have effects on cognitive and psychological development for a younger person. And I think that's something to take serious. I don't think the argument that it's a gateway to other drugs is a myth. I think there are, again, studies on both sides and studies on the side to suggest that it is a gateway. I found one older study from the American Academy of Pediatrics saying that adolescents who use cannabis are 104 times more likely to use cocaine. I also think there is evidence out there that I found, again, there's arguments on both sides, to support the argument that it can lead to greater offenses. I found one study from the American Journal of Public Health that actually tracks statistics, and between 2000 and 2018 found that cannabis-involved traffic fatalities doubled, and cannabis-involved traffic fatalities with alcohol included doubled. And that causes me, from a public safety perspective, to have some serious concerns. In terms of no one wants to see this in the hands of kids, I don't want to see it in the hands of anybody, quite frankly. I think it's a poor comparison to suggest that going home and having a can of beer is the same as going home and having marijuana. And in terms of not wanting to see it in the hands of kids, I think you're going to see it in the hands of kids as you decrease the penalties, because it makes it less of a consequence to simply pay $50 as opposed to $500. In terms of some of the questions that I had, when I'm done with my comments, is, I took a look through the proposed change to the ordinance, and then took a look at our current ordinance, which is in front of me, and then flipped to the penalty section. And this is why I'm perplexed, because we are arguing, we're suggesting that, well, it's $500 and that's a lot of money and we need to decrease it to $50. Right now, as I read this, someone can be fined on a first offense not less than $5, on a second offense not less than $10. And the other thing that confuses me about this is, if we're decreasing it to $50, as I read the proposal in the packet, this doesn't distinguish between first and second offenses. So offense number 1 is $50 and you can violate it again and it's $50, at least as I read this. I wasn't aware until Teresa gave her discussion, and she did a terrific job, about the diversion program option. I think it's great, and actually it's more of a benefit to have it go into diversion if her office feels that that is appropriate, and keep it off of CCAP, because I agree with her. I don't do criminal law, but I've had questions from folks before. I at least know the difference between a forfeiture and a misdemeanor and a felony, but CCAP is CCAP to a lot of people who aren't in the legal world. And if it's on there, it's on there, whether it's a forfeiture or a misdemeanor, and there's plenty of people who don't know the difference. So I think the option for the diversion program is excellent. I'm probably missing a lot, but I think it's pretty obvious where I stand on this. The one other comment that I will make, from somebody who gave public comment on drug screening and drug tests and employment, you know, they are out there. And are we discouraging people as we encourage the use of marijuana? Are we discouraging people from actively trying to find employment because they're going to fail a drug test? This is the worst time in the world to be having that conversation, when we can't get people to fill jobs to begin with. So I'm opposed to this. I'm going to be voting no, and that's all I have. But thank you, Mr. Chair, and Mr. Chair Butke as well.
Thank you. We'll have Supervisor Gibbs, and then I'll turn it over to Supervisor Budke for his committee for some comments. So go ahead, Supervisor Gibbs.
Chair, and thank both of you for having this issue before us, and thanks, Supervisor, for bringing it forward. I think what we have learned from not only the District Attorney's Office, the Sheriff's Department, you know, I serve as the Vice Chair on the CJCC, Criminal Justice Coordinating Council. And that council has a lot of individuals represented on there. We have representation from the judges. We have representation from county leadership. We have representation from county administration. We have representation from the county Public Safety Committee. We have representation from the Public Health and Human Services Committee. We have the sheriff's department on there. We have the Wausau police chief or his designee on there. We have the district attorney's office on there. We have the clerk of court's office on there, social services department on there, criminal justice coordinating alternatives, victims advocates, community, women's community shelter representation, probation and parole, just to name some. I've also missed additional. I think what we've heard here is that there's the possibility of having this being reviewed. I don't think this is ready for prime time, and have, I think what would be beneficial is to have this referred potentially to the CJCC and have them provide input and recommendations on if any, on the changes. As we heard from the Sheriff's Department, there's a great opportunity to review our forfeiture system and understand its impacts on not only how it impacts each of the other departments, whether it be the clerk of court's office, whether it be the district attorney's office, the judges, the courts. If I would offer a suggestion, the suggestion would be that it be referred to there, but it is this committee's pleasure. Thank you.
Okay. All right, from the Health and Human Services Committee then, Supervisor Harris.
Hi, thank you, Chairman Bucky. So I guess I have some clarifying, I guess, questions that I need to ask. Can you hear me?
Not right now.
We do not hear you.
We did briefly.
You can hear me.
Are you there,
Okay,
Supervisor
can you hear me?
Harris?
Hear me?
Oh, he just dropped off.
Anyone hear me? You hear me now?
Barely, Supervisor Harris. I don't know what's happening there.
I've been having technical issues. So I had some. So in the discussion, it was mentioned, I think when Supervisor, not this would lead to just, it would just be $50. And they Deputy Bill mentioned that the fact that there could be other fees and other things, that there were definitions that needed clarification. Question on this is, and to what you said, to what was said, a work group to look at the ordinance in and of itself and to look at matter as opposed to this particular ordinance, and for that CC to then to come up with something that will help law enforcement move.
Supervisor Harris, you are Supervisor Harris, you're cutting in and out a bit. We're getting much of what you have to say, but not all of it. And I want to do justice to you. You think it would be helpful for you to sign out and then try to sign back in? I do have Vice Chair McEwen in the queue as well, and then we'd come back to you. Would that be acceptable?
Yes, that would be fine.
Okay, try that. Thank you. Vice Chair McEwen.
Thank you, Bucky and Chairman Boots. I appreciate this this discussion, and also want to thank the District Attorney and Corp Counsel and Chief Deputy Billups for some of the information that they provided for us. It makes it a little bit clearer. However, when I read this resolution too, I had some concerns and questions, and I believe that this resolution is downplaying and minimizing the negative effects of marijuana by reducing the penalty to no more than a parking ticket. I did teach the DARE program for 12 years, and marijuana is a gateway drug. Also, I believe, looking at the mission statement for public safety and health and human services, it would not support moving this resolution forward. The other question I had is, and maybe Supervisor Johnson would know this, the $50, does that include the penalty assessment, court costs, and the other costs that are associated with a ticket that's written by the county that the courts have to pay? And like I said, I would not be supporting this resolution either if I was on public safety or the health and human services. But just some questions as far as the court costs issue. I don't know if the district attorney would know that or clerk of courts.
Supervisor
Thank you.
Johnson, would you care to address that?
Yeah, thank you, Chairman Butke. The way I envision this is if the ticket is paid, it doesn't incur court costs. Like a parking ticket. If you pay your parking ticket, you don't have court costs. If you contest it and you go to court, you rack up court costs. That was the way I envisioned this being enacted.
Got it.
Thank you.
All right. That satisfy your question, Vice Chair McEwen?
Yes. Thank you, Supervisor.
Okay.
Thank you.
Supervisor Harris, I think you're back with us. You want to give it another shot?
Yes, thank you, Chair. Are you able to hear me now?
It's very quiet, and there are times when you cut out. Can you speak loudly and directly, and we'll give it a shot, okay?
Yes, so on the, if it were $50, is it, it seemed from the, not only be $50, that there are other court costs potentially and other things, because it's not on how to apply that with the current ordinance. So my question is, this ordinance is what we really need is more to move forward with a work group like at the current ordinance as it stands and make appropriate adjustments. Does I want to hear the opinion too of this. I think Sheriff Bill said group might be a good idea. I was wondering if that would be useful in their process because I think it's important.
Supervisor Harris, you are still cutting out quite a bit. Supervisor Harris, I think you get the gist of what you're asking. I think he's asking Deputy Billup whether you would find usefulness in having a work group to take a further look at this.
I think I understand Supervisor Harris's question. I hear you, Chip. I believe I understand Supervisor Harris's question, and it goes right back to exactly what we were talking about. And I think he's right, is that I don't know that we understand or know exactly how our ordinances derive a penalty, if you will. If this ordinance, the way it's structured right now and the way that Supervisor Johnson is proposing it, would be very different from everything but a parking ticket. Every single other ordinance that we enforce has some other form of structure behind it that has those costs built in, whatever they are, to the best of our understanding. I met with the clerk of courts, Kelly Schremp, and we looked at it, and we looked at examples of other violations, let's say a disorderly conduct, and it has a penalty or a deposit, and then all of the other costs that are associated that comes out to a total value. And we have set up every single one of our ordinances to be consistent at that $250.90, so that we have consistency and structure in all the ordinances we enforce. Now, that may mean we need to look at each one of them and do something different, but I think that we need a better understanding of where these numbers come from and how they happen, because I believe personally that when you're the deputy or the officer, you should not be making a decision as to what a person should pay based upon a violation. that goes right back to quota systems that we should not be involved in whatsoever in any way, shape, or form. I believe that legislatively, those dollar amounts should be assessed, and it's what we hand a person when it's there. It's because it's what came from the legislature, if you will, or the county board, or a committee that sets that, not law enforcement. The example I'll use is when a speeding citation is issued, the deputy does not choose the value of that citation. That is actually provided to us by the state of Wisconsin. And it's consistent for everybody that's stopped and cited at that speed or for that violation. And I believe that that's what we should have for all of our county ordinances, so there's consistency in how they're assessed.
All right. Supervisor Johnson.
Thank you, Chairman Butke. The chief deputy hit it right on the head. The intent of this is to treat it like a parking ticket, period. That was the intent of this, was to, if it's paid, it doesn't rack up the court costs that are associated with it. Like a parking ticket, if it is paid on time, there are no additional costs. But and it does provide certainty. It does take away any range of potential fines, as the state statute is written, between $500 and $500. It makes it an amount certain. So that was a very good analogy. Thank you for that. But the intent was to make it akin to a parking ticket. Thank you, Mr. Chair.
Go
Supervisor
ahead.
Mask?
Gene, can you wait till Bill wants to speak one more time, then you can do it, if that's okay?
Yes, I couldn't raise my hand, so yes, just let me know.
All right, thank you.
I just want to make sure that I didn't confuse anyone. The citation we issue for possession of marijuana today is a certain number. It is a definite number. It's $250.90. So that has never changed. That's what we do today. So I just want everyone to know that that number does not vary between 5 and 500.
Go ahead, Supervisor Mask.
Thank you. For the most part, I agree with just about everything Supervisor Johnson said. In my heart of hearts, I have known people who have smoked pot forever, and a lot of them don't even do it any longer. It was just something they did, and some preferred it over alcohol. I have two sons, ages 50 and 48, and a brother who's younger than me. All of them dabbled in it. When my kids were teenagers, you could get anything you wanted. And they shared that with me, and I respect them for that, and tried to make sure that they didn't get into trouble, and for the most part they didn't. But alcohol was available, and so was drugs, and pot was too. When I was in high school, it was available, and that's a long time ago. I just don't want to see people being demonized and put into a system for recreational possession, because I think this is going to be legalized at some point. And to have people with a record for misdemeanor possession, I think is wrong. If you're a repeat offender, if you're a dealer, by all means. But most of the people I know who have one OWI never get another one because they're scared blankless. I just think that this needs to be discussed a little bit more. One thing that comes to mind is a really good friend of mine who is 73 years old, and she was raped by her uncle when she was 16 and gave birth to a child when she was 17 before she graduated from high school. She had a terrible time because her family was not supportive of her. They blamed her. And when she finally opened up to me when we worked together, she used marijuana to keep her sanity and to keep herself on the straight and narrow, preferred that over alcohol and drugs recommended by a doctor. She still uses it to this day. The woman has held a productive life. She held jobs in very respected professions, never got arrested, never got anything for illegal possession, never anything. So there are people out there who do use marijuana for the reasons that some of us can't imagine. And She could have gone on prescription medication from a doctor, that would be legal. Or she could have drank, that would be legal. I think it just needs a lot more discussion because you're pigeonholing people. And like I said, these people that I know never went beyond having a few joints during their formative years. Thank you.
Is there any further discussion, I guess, for the public safety on the proposed Mr. Opal's motion? No further.
Well, Chairman, just as a point of order, I guess, I would have some comments. I'm not so sure that I should be commenting on the motion that's on your floor, though, at this point.
You're a supervisor, you can comment.
I can do what I want. Huh? Okay. Because I have to say, I agreed with Chairman Gibbs's comments. I like the idea of referring this to the Judicial Council Committee. I think that's an excellent idea. You have some good minds together from various walks of life that can take a good look at this. And if a change needs to be made, that could be crafted appropriately. I do agree that I don't think this is ready for prime time at this point. But I mean, when we get to our vote, I'd kind of be looking for a motion to table at this point. But that's where we're at.
And I will say, as I am on the CJCC just by default because I'm the chair of the public safety, so is Supervisor Budke, and so is Chairman Gibbs. So even if we vote this down today, I'm fairly certain we're going to be discussing it at the CJCC because we already have the data out there. So anyway, that being said, I guess with no further comment, I will put this up to a vote. And all in favor? Aye. Is there any opposition?
Mass. I don't agree that this should be passed.
Can you clarify the motion, Chairman?
The motion is to not move this forward. So, Gene,
Can you call the vote again then, Matt?
Yeah, I'm going to start. I'll do it again. So, all in favor, signify by saying aye. Aye.
Aye.
Aye.
Is there opposition? So it's
So I'm
unanimous.
confused now.
So an aye vote says this is done. It's a done issue. A nay vote says that you would like to see this go further.
I vote that it goes further. So I vote no.
Okay. So then we have one nay. Thank you. And then I will turn it over to Health and Human Services.
Okay, for Health and Human Services, and I would entertain a motion as to what's your pleasure at this point. Supervisor Harris.
Yes, I would, because I know I'm going in and out, but I would to CJCC to further assess and develop an ordinance, bring before a full county board. We need further education and discussion, and the ordinance be clarified.
Okay, you are cutting out, but I do see what you chatted here. Is your mic on? Good. It is now. Supervisor Harris said, I would like to propose a motion that we move the ordinance to the CJCC for further access and develop, that they develop an ordinance for discussion before the full county board. All right, that's what he's motioning at this point. Is there a second?
Second.
Okay, a second from Supervisor Van Cray. Any further discussion from the Health and Human Services Committee members?
So I guess I have a clarification question.
Go ahead.
The clarification question, just being a member of the CJCC, was that you would want them to create a new ordinance, or is it possibly leave what we have, or do you want a new ordinance out of this?
I would refer to Supervisor Harris if we can hear you as to what specifically you're looking out of that motion.
Yes, so the current ordinance clarification, as I've heard it from the sheriff, ordinance. So what my preference would just be, they do a new ordinance that clarifies. But obviously, we need something different moving forward. Either that already had and something new, or to move forward with something new.
Okay, I think I get the gist of it, Supervisor Harris. Chad, would you like to speak to that?
If I could, I'm trying to frame what we're trying to solve. From the conversation we've had today, as I understand it, I believe that by and large, we're in agreement on the ordinance itself, outside of the penalty, we're pretty okay with. There's not much change that needs to take place. I believe that the 25 grams would be one change, and then the other change is the penalty, if you will. Are those the two things we're looking at? Because I'm a part of the CJC as well. And the reason I'm asking is I'm going to be tasked with being a part of helping understand what we're trying to solve. So I just want to be clear on that. I don't know that we need to rework the entire ordinance, but I think that what we're trying to solve is, if we're in agreement about the legalization, the decriminalization, we're all in agreement that that's not going to happen. And we can't do that. So to change the ordinance and the structure of the ordinance, to me, doesn't make sense. I think what we're talking about right now is penalties, and what should a penalty be for that ordinance. But if we're going to do that, we should be looking at all ordinances. And that's how I understand our mission moving forward. And if I'm wrong, I guess I need clarification too.
Okay.
Supervisor Harris, if I may.
Go ahead.
I would agree with Sheriff Billa. I just had them to have the ability and the freedom, if they needed to make further changes that they felt through this process. But if really the wish is just because we're just dealing with those, I will revise my motion then to further and assess and develop the current at those two issues.
So if I understand correctly, that what you're saying is you want to further have that committee further discuss those two issues regarding grams and the penalty, correct? Is that?
No.
Correct, and to look at the ordinance, changes to the ordinance after developing an assessment, and present that to the Health and Human Services.
Administrator Leonard is on. Go ahead.
I'm going to attempt something that I'm rarely successful at, and that's brevity. In the interest of brevity relative to your motion, may I suggest that you simply refer the matter to the CJCC for consideration and a recommendation back to the Public Safety and Health and Human Services committees, or the full board, but less might be more here in terms of what you're trying to accomplish.
Okay, yes, I will go with that. Less is more, and we'll deal with it when
we have progress. Good. All right. Supervisor Van Cray, do you agree with the change in that motion? A friendly?
Yes, I do.
Okay, very good. Okay, we have a motion, a second, to refer this proposed ordinance change back to the CJCC for further consideration, with then to bring something back, hopefully, to this joint committee. Any further discussion? Seeing none, I'm going to call the question. All in favor, say aye.
Aye.
Opposed, same sign. That motion is carried. Thank you. All right. take it from there? Okay. We will move on then. Under item 5, educational presentations, outcome monitoring reports, we don't have any today. Our next meeting time, location, announcements, and agenda items. Again, committee members are asked to bring ideas for future consideration. I either bring it to myself or Administrator Leonard to go forward with that. Our next meeting for Health and Human Services is slated for February 2nd at 4 o'clock, and Public Safety is slated for February 2nd at 1:30. So with that, I would entertain a motion to adjourn. Supervisor Opal, well, you're not even, yeah, you're part of this, yeah.
I could make it anyway. I'll make a motion to adjourn both committees.
Okay. We have to,
We have to do it per committee, so.
Well, maybe I get a two for it.
we'd have to give you a wage increase.
We have
That's not gonna
we have a motion by Supervisor Opal for public safety. Do I have a second?
Second.
Jean has a second. All in favor? Aye. Any opposed? Motion carried.
Aye.
Great. Okay, and for Health and Human Services, do I have a motion to adjourn?
So move.
Okay, Van Cray, and do I have a second?
Supervisor Goddard, I second.
Supervisor Goddard with a second. All in favor, say aye.
Aye.
Aye. Opposed, same sign. The motion is carried. We are adjourned. Thank you.
Now, how do I get those 2 hours?